If the Supreme Court rules narrowly on the safety exception, if they say that state courts can hear negligence cases against brokers, that's a win for injured parties. That's a win for truck drivers who get hurt because of broker negligence. What's up, guys? Welcome back to Young Diesel Trucking Reacts. I'm your host, and today we're breaking down something that's about to shake the entire trucking industry to its core. I'm talking about a Supreme Court case that could fundamentally change how you get compensated, how you get protected, and how liability works in this industry. Now, I know what you're thinking. Supreme Court, legal stuff, but stick with me, because this directly impacts every single one of you who works in trucking, whether you're an owner-operator, you run a fleet, or you work with brokers. This isn't just legal mumbo-jumbo. This is about your money, your safety, and your rights on the road. We're going to be breaking down two massive cases that just went to the Supreme Court. Montgomery versus Caribe II and Cox versus TQL. These aren't random names. These are real companies, real situations, and real consequences for the trucking industry. So grab your coffee, settle in, because this is about to get intense. Let's start with the basics, because if you don't understand what the Federal Aviation Administration Authorization Act is, you won't understand why this case matters so much. Now, I know it sounds crazy. Federal Aviation Administration, we're talking about trucks, not planes. But here's the thing. Congress bundled this law with aviation stuff, and inside it is something called the F4, and buried in that F4A is language that preempts or basically overrules a ton of state regulations when it comes to trucking. Think about it like this. You've got 50 states, right? And every state wants to make its own rules about trucking. But Congress said, no, we're going to have one set of federal rules that trumps all the state stuff. That's preemption, and it's been the law since the 1990s. But here's where it gets tricky. Congress also built in what's called a safety exception. This safety exception says that states can still make laws about motor vehicles if it's about safety. So states have some wiggle room. They can still protect their citizens with safety regulations. The problem? Nobody really knew exactly how wide that wiggle room was, and that's where everything falls apart. For years, courts have been arguing about what counts as the safety exception and what doesn't. And that disagreement has cost companies and individuals millions of dollars in litigation. Okay, so here's where brokers come in. Brokers are the middlemen. They connect shippers with trucking companies. They match loads with drivers. They're basically the facilitators of the whole system. Now, for years, brokers and third-party logistics companies have been trying to stay out of state court. They've been arguing that the F4A protects them from state negligence claims. They say that because they're not technically motor carriers, they shouldn't be liable for accidents or injuries under state law. So you've got situations where a broker hires a motor carrier or a driver. That driver gets in an accident, someone gets hurt, that person wants to sue. The Ninth Circuit says the safety exception is pretty broad. The Sixth Circuit agrees. So if you're in California, Nevada, Arizona, or anywhere else in the Ninth Circuit, or if you're in Kentucky, Tennessee, Ohio, in the Sixth Circuit, state courts might be able to hear your case against a broker. But the Seventh Circuit says the safety exception is narrow, and the 11th Circuit agrees. So if you're in Illinois, Indiana, Wisconsin, or Florida, Alabama, Georgia, state courts probably can't hear your case. The F4A protects the broker. This is called a circuit split. And when you have a circuit split where different federal courts are interpreting the same federal law in completely opposite ways, that's when the Supreme Court usually steps in. Because think about the chaos this creates. You've got 50 states. You've got 13 federal circuits. You've got companies operating nationwide. And depending on where your accident happened or where the broker is located, you might have completely different legal outcomes. A broker could be liable in one state and completely protected in another. A truck driver could win a negligence case in California, but lose the exact same case in Florida. That's not justice. That's a mess. And the Supreme Court is probably sick of dealing with all these cases coming up. That's why they're taking this on. They want to settle this once and for all. All right, so let's talk about the actual cases. Montgomery versus Caribe II and Cox versus TQL. These are the two cases that are going to Supreme Court. Montgomery versus Caribe II is a marine transport company. They brokered trucking services. Someone got hurt. There was a negligence claim. The lower courts said the F4A protects Caribe II. The case went up on appeal. Interesting thing here is that even though Caribe II won at the circuit level, they actually supported the other side asking the Supreme Court to review it. Why? Because they want certainty. They want to know once and for all whether they're protected or not. Cox versus TQL is Convoy TQL, one of the largest freight brokerage companies in America. Similar situation. Negligence claim. Cox says TQL should have been more careful about hiring or vetting. TQL says the F4A protects us. The cases went in opposite directions through the courts. Cox's case actually came to the Supreme Court from the Sixth Circuit, which was more favorable to the injured party. Here's what makes this absolutely nuts. Both of these brokers won at the circuit court level. Both of them were protected by the F4A, but they're asking the Supreme Court to take the case anyway. Why would they do that if they already won? Because uncertainty is expensive. These companies operate nationwide. They need to know the rules of the game. They need certainty so they can do business without constantly fighting in court. And interestingly, even the brokers themselves recognize that having one clear rule is better than the current chaos, even if that rule might be slightly less favorable to them than the current situation. So let's get real about what this means for you as a trucker or someone in the trucking industry. If the Supreme Court rules narrowly on the safety exception, if they say that state courts can hear negligence cases against brokers, that's a win for injured parties. That's a win for truck drivers who get hurt because of broker negligence. It means more accountability. It means brokers have to be more careful about who they hire. They have to be more careful about vetting safety records because they know they can be sued in state court. But here's the flip side. If brokers face more liability, insurance costs go up, operating costs go up, and guess who that gets passed to? You. The trucking companies pass it to the owner-operators, pass it to the drivers. Rates might not go up proportionally, but it could tighten margins across the board. On the other hand, if the Supreme Court rules that the F4A broadly protects brokers, that's a loss for injured parties. It means brokers have less incentive to be careful. It means if something goes wrong, you might not be able to sue them in state court. You'd have to go federal, which costs a fortune. But it does mean lower compliance costs for brokers, which theoretically could mean better rates for carriers and drivers. The truth is, this case is about finding the right balance. It's about figuring out how to protect people who get hurt while not crushing the brokerage industry under liability costs. But here's what's undeniable. The current system is broken. Multiple courts can't agree. Cases cost millions. Companies waste resources fighting about jurisdiction instead of focusing on safety. This Supreme Court decision is going to force some clarity on this. And that clarity, even if it's not perfect, is going to be better than what we have now. Guys, this is the kind of story that doesn't make headlines in the mainstream media, but it absolutely impacts your livelihood, your safety, and your rights. The Supreme Court is about to make a decision that's going to ripple through the entire trucking industry for the next decade or more. If you work in trucking, if you care about safety, if you think brokers should be held accountable for negligence, or if you think they deserve protection from frivolous lawsuits, this case matters to you. I'm going to keep you updated as this case develops. If the Supreme Court makes a decision, we're going to break it down in a future video. So make sure you're subscribed, Hit that notification bell so you don't miss when we cover the Supreme Court's ruling. Drop a comment below and let me know what you think. Should brokers be held liable for negligent hiring? Should state courts be able to hear these cases? Let me know your take in the comments. Thanks so much for watching Young Diesel Trucking Reacts. I'll see you in the next one. Stay safe out there.